afternoon. Welcome to the February edition of my New York Workers' Compensation Construction Claims webinar series. My name is Tashia and I'm a partner here with LOIS Law Firm, where I handle the defense of workers' compensation claims that arise out of construction accidents. That's all I do, and even more, I oversee a team of attorneys and paralegals whose focus is on defending workers' comp claims that arise out of construction accidents. Our practice is based in New York. That's all we do. It's focus. I'd like to say that we're experts in the area. I've been doing these construction claims for many, many years now, and one of the things I've come to learn is that it's so important to be collaborating with the General Liability Defense Counsel. The collaboration is important because it ultimately helps to develop strategies and tactics that would reduce exposure to the client. I've been doing this webinar series for about 2 years now, and every month I focus on a small component of the entire collaboration process. I go through some of the basics so we understand a little bit about the construction claims litigation, how that works, and the New York, the workers' comp side of it, and how that works, and how to collaborate between the two. So this month, I just wanted to give a nice little overview on construction litigation claims, how it works. I'll talk a little bit about New York labor laws and the types of accidents that you will frequently see, and also some trends that continue in the New York construction claims, especially some things we've seen over and over again as the years go by. So let's talk about the law. I'll be very brief. I'm not going to bore you with this, but I think it's important to understand the laws that are at play in these construction claims. And it's always, I think it's always important to be familiar with them when you're talking to your attorneys or the clients when they're asking about the mechanism of injury and which laws that are going to be applied, and the implications and the potential exposure. So the construction laws, aka the labor laws, section 200, let's start with that. So these are the ones, like, keep in mind that some work accidents are caused by defective tools or use of tools or dangerous conditions. So this is pretty much governed by section 200. And it's where the accident is caused by the manner in which or tools that the contractor uses to perform the work, or where the accident is caused by a dangerous condition on the job site. The Labor Law 200, it must be shown that the contractor had authority to dictate the work that was being performed in order for the contractor to be found liable. And it must also be shown that the contractor either created the dangerous condition or knew about the condition and did not remedy it. So I'm sure as you're talking to your defense counsel, you're going to hear them saying, well, you know, the condition was on the job site. We're trying to get to the witnesses to see if they knew it was there, when it was created, why it was created, did anyone do anything to fix it? And these are all questions that you should be asking your attorneys also in order for you to get an assessment of your potential exposure in the claim. Next, we have Labor Law Section 240. This is the big one. This, I feel like, is the majority of claims that we see on the workers' comp side. Falling from a scaffold, falling from a ladder, falling from, you know, some kind of a makeshift step stool or buckets piled on each other. This one's commonly referred to as the scaffold law. It pertains to where there was some type of elevation involved in the accident. So contractors are required to provide workers with safety devices and measures to protect them from elevation-related accidents and injuries. So one of the things that's usually looked at in these particular accidents is whether the workers, the claimants, had all of the safety devices, the harnesses, the PPE gear, and, you know, all of the safety measures that are necessary to prevent an accident. And for under Section 240, the only defense is sole proximate cause. We have Labor Law Section 241. This contains specific provisions for construction, demolition, and excavation in job sites, and addresses falls and cave-ins and how job sites must be arranged to protect workers. So these are the ones, so this is the one that governs the claims where the claimant said they fell into a hole in the ground. You know, there was some kind of an opening that wasn't properly covered. That's kind of like the bulk of the claims that at least we see on the workers' comp side that falls under a Section 241. All right, so now that we have an understanding of the laws that govern these construction claims, at least the most prevalent ones that we see on the workers' comp side, and an understanding of the kind of accident that should trigger collaboration between workers' comp and general liability defense counsel. Talk about some of the civil milestones. What happens in the process of a general liability litigation? Now, as you may already know, workers' comp claim goes quickly. It goes fast. It goes 0 to 60 before you can even blink an eye. However, on the general liability side, it can be dragged on. Now, something to keep in mind is the statute of limitations is 3 years for negligence claims. So the claimant has 3 years to bring their claims. A lot of times your workers' comp claim is already closed out by the time they're starting litigation in the civil side. For accidents that were, or the accidents that occur in public entities, there must be notice to the public entity within 9 days. That's a very short time frame, and the claimant must provide notice to the entity that it will be filing suit. 50H hearings for public entities. This is essentially a deposition, even though it's not called a deposition, but it's one where you would get to question the claimant about the accident, his background, you know, things like his personal life, criminal history, and so forth, just to get an idea or to gather as much information as possible about who this person is and the claim that he's bringing or intends to bring against the public entity. Then there's the filing of the complaints. Then an answer must be filed and a bill of particulars. Bill of particulars usually lays out all of their claims, the specific injuries that the claimant has endured, and what he's claiming as a result of the negligence of the entity or the company that he's suing. And these can be amended. So I've seen amended complaints, amended answers, amended bill of particulars. If the claimant undergoes a surgery or something like that, they would file an amended bill of particulars just to lay out all of their, I guess, grievances. And then there are formal depositions. There are party and non-party depositions. There are medical depositions of doctors. The depositions on the general liability side are very, very different than the ones on the workers' comp side. On the workers' comp side, depositions usually only of the doctors, and they are much shorter. On the general liability side, they're much more detailed. They can last for several hours. And it makes sense because that's where your exposure is. It's on the general liability side. That's where you're paying out millions of dollars for claims that didn't even happen, right? And then there are mediations. Mediations where you go in front of a mediator and the parties present their positions and the mediator helps to facilitate a potential resolution, a potential settlement between the parties. There's also IMEs and expert reports. The same way we get IMEs on the workers' comp side, IMEs are obtained on the general liability side. Same thing for expert reports. Expert reports can be anything like a vocational or rehabilitation report, or any kind of a report that would analyze the claimant's future earnings and stuff like that that we would use to help calculating potential exposure. I focus on these civil milestones because they are important in knowing when we should knock on our GL defense counsel's door and say, hey, we need to talk. You have this deposition coming up. I need to give you an update on my workers' comp claim. Oh, you have a mediation coming up? Well, let me tell you, we just got this great finding in our end 2 days ago. The lumbar fusion was disallowed. These are all things that we should be thinking about. Every time we hear one of these milestones are coming up, we should be talking to our jail defense counterpart so that they have all of the information they need going into each of these events so they can properly ask questions, analyze the facts, get all of the information they need to provide defense on their end. Some of the trends we've been seeing. And if you watched my webinar last year, you've heard me talk about some of these. And it's really because these are the most important ones, they're the most prevalent ones, and they're the ones we keep seeing over and over. I guess hence the reason they're called trends, right? So we all know the workers' compensation claim goes by in a flash, and the system is very claimant friendly, and the claimants are using the workers' comp claims to maximize the value of their general liability claim. They're getting bogus claims established. They're getting body parts put into the claim that were not even injured, and they're undergoing surgeries that are not even necessary or even causally related. However, because the claimant, the doctors, and the attorneys are all in cahoots with each other, they come up with this grand plan. I'm convinced they have a checklist of the things that need to be done in order to reach a certain threshold value on the general liability side. But that's just my opinion. So they're definitely working up their workers' comp claims. They're milking it, and they're presenting it to a mediator or the jury or the judge and the civil side saying, well, I was injured on a job site. It was a construction accident, and I had all of these injuries, and I had to undergo all of these surgeries, and I can never work again, even though I'm 35 years old. Yes, that's the kind of claims that we see. So let's be cautious about this, and it's the main reason why collaboration is so important between your workers' comp attorneys and your general liability defense attorneys. They need to be talking to each other and getting an update in each other's cases in order to, dispel some of these actions that the claimant is trying to get into their general liability claims. We are seeing more fraudulent claims. We're doing the investigation, we're talking to witnesses, and we're just seeing more claims, unwitnessed claims, or where the claimant is claiming that it happened, 2 weeks ago when the job site was in a completely different condition. They're really talking to each other, they're talking to their unions, they're talking to their attorneys, their friends who have claims, and they're coming up with all sorts of creative ideas to file workers' compensation claims. In order to combat these, I think the investigation that I always talk about, the initial investigation, as soon as we get word that an allegation is being made of a work site accident, I think you need to get your investigators out there, and you need to put together a strong investigative report. So after we've been able to gather up enough information and raise fraud, we've been seeing claimants counsel and their GL counsel, reaching out, asking, begging us to put off fraud litigation. And they usually say, well, we're trying to settle this, so we don't want to litigate right now. Can we just put it off? Can we ask the judge for an adjournment? And my response is no. We're going to pursue the fraud claim. If we lose before the law judge, we're going to file an appeal because the board panel is going to look at our evidence a little more keenly and see that the claimant's a fraud. So it happens, I feel like once a month, we're seeing a situation where there's a fraud case. and they're reaching out to us saying, oh, we're trying to settle. And then we talk to our adjusters and they're like, no, we're not trying to settle. No one's reached out to us about settlement. That's a lie. The next thing is traumatic brain injury and psych claims continue to rise. Last year, when I talked about traumatic brain injury, I mentioned how they're like the new spinal fusion in New York, you know. A claimant falls and injures his knee with no impact to the head, and all of a sudden, 3 months later, he has traumatic brain injury. Psych claims, you know, it's bizarre, but we've seen psych claims arise from a simple hand injury or a foot injury. It's just insane how they're working up these claims and using the psych claim as a reason for not being able to go back to work because they're claiming that they're not mentally fit. Even though their hand has been resolved, they're not mentally fit to go back to work. Another trend that we continue to see, global settlements continue to win the day. We are pushing global settlements with our clients where it makes sense, of course. This is where you're closing out both the workers' comp and the general liability claims at the same time. Generally involves a lien waiver or partial lien waiver to close it out, and it certainly saves a lot of money on the workers' comp side, and then overall also because you're using it as leverage in the negotiations. So these are the trends we've been seeing for the past several years. We continue to see them. We're keeping our eyes out for any new trends, and of course, we're going to come up with ways to try to combat them. So as I see them in the upcoming months, or anytime in the future, I'll be sure to incorporate them in my webinar and share anything that's interesting with you. All right, so how can we prevent the exploitation of New York labor laws? Well, collaboration. Collaboration. That's the key. Your workers' comp adjuster needs to be talking to your GL adjuster. Your workers' comp defense attorney needs to be talking to your GL defense attorney. Pick up the phone, call each other, talk about the milestones, ask questions, ask what's the next step. Tell them what's going on in the workers' comp claim. Was a surgery just authorized or denied? Was there a fraud finding? Did we lose the fraud trial? Was a denied claim established? This is all information that would be helpful to your GL component because they're also gathering information that they need to defend their claim, right? To contest all of the body parts the claimant is contesting on their end. If your claimant has returned to work, that's important for your general liability defense attorney to know because it goes towards lost wages and the calculation of future lost wages. And to work then, there's no lost wages. Conduct investigation immediately. I talked about this a few minutes ago. I cannot stress enough. Getting an investigator, I know it can cost a pretty penny, but it's really worth it in the end. One of the things that we do is we give the investigator pointers when they have to go out, what to look for, the questions to ask, the people that they're looking for, the information we need. So your attorney should definitely be talking to the investigators also. Using collateral estoppel. I think this is extremely important. I've seen many cases in which collateral estoppel was used. For example, if a body part was disallowed in your workers' comp claim, let's say the claimant was claiming the neck, and after litigation, it was disallowed and it was affirmed on appeal. This is big for your general liability claim because now the claimant doesn't have a basis for claiming a neck injury, which could potentially value millions of dollars on the general liability side. Using the fraud findings, as I noted, go for it. Raise fraud. Anytime there's a material misrepresentation, raise fraud, present the evidence, let the judge make a decision, file an appeal if you have to, and try to cut off the claimant's benefits. And you'll see, once you cut off the claimant's benefits, they stop treating, obviously, because they were treating only to get their benefits going every 90 days. And then all of a sudden, you'll see also that the general liability attorneys are making demands because they know that their case has been shot. All right, so I think at the end of the day, it's a reality that the system's very favorable to the claimant, or they're called the plaintiffs on the general liability side. But if we take the initiatives, start the investigation early, and engage in joint collaboration with your workers' comp and your general liability defense counsel, I think it will make a very big difference in terms of how the cases end. And I've definitely seen millions and millions of dollars in being shaved off of claimants' initial demand for settlement. And it's only because they never had a strong claim, and because of the collaboration between the two sides, we were able to shed light on all the deficiencies in the claim, which led to more reasonable settlement, which at the end of the day is our goal. All right, so I hope this was helpful. I'm trying not to go into too much detail and bore you with the laws and how these things work. But if you have any questions, please feel free to send them to me, give me a call, send me an email. I'd be happy to chat with you. Thank you for joining me this month. Next month, March 7th. So we're always doing these webinars on the first Monday of the month. Next month, we're going to talk about an overview of New York workers' compensation law. And I'll focus on, the milestones again, and why it's important that we keep track of the milestones and communicate them with your general liability counsel. All right, everyone. Thank you for joining me. Have a wonderful February. Stay warm. Hopefully spring's going to be here by the time next month's webinar. Take care, everyone.